Welcome to Part 2 of the FIPPA Awareness Presentation on Access to Information. The FIPPA Awareness Presentation, prepared by the Information and Privacy Policy Secretariat, has been broken down into 5 parts that together are intended to help employees of public bodies feel more comfortable with how the Freedom of Information and Protection of Privacy Act, or FIPPA, affects their work. The other 4 parts of the FIPPA Awareness Presentation are Part 1, Role, Scope, and Key Definitions, Part 3, Protection of Privacy, Part 4, Oversight and Accountability, and Part 5, Things to Think About. During the second part of the FIPPA Awareness Presentation on Access to Information, we'll discuss how individuals make a request to access records under FIPPA, the steps public bodies can take to coordinate the response to those access requests, and what factors should be considered when making an access decision. If you have not yet listened to Part 1 on role, scope, and key definitions, please do so first, as it contains information that will help you to better understand this part of the presentation. The purpose of the Access to Information part of FIPPA is to allow any person, which includes individuals, corporations, businesses, or other organizations, the right of access to records in the custody or under the control of public bodies. This right of access is subject to limited and specific exceptions, as set out in FIPPA. The Access to Information part of FIPPA explains how a person can exercise their right of access and how public bodies are to respond to a person's request for access to records. It should be noted that the formal access request process under FIPPA is not always necessary to provide someone with access to records. Public bodies already disclose information in other ways, such as through existing processes, some of which may require the payment of fees, and posting information on websites. The formal access request process under FIPPA should be used when people ask for records that contain another person's private information or other confidential information. Making the request under FIPPA allows a public body the opportunity to illustrate why they are authorized to refuse access to some information and gives the applicant the right to make a complaint about the access decision. Otherwise, when there is no concern about disclosing someone's private information or other confidential information, other ways for proactively disclosing information in which there is a public need or interest are encouraged in the spirit of being an open, transparent, and accountable government. But the focus of this Access to Information part of the FIPPA Awareness Presentation is on the processing of those access requests made under FIPPA. When your public body receives a request for records in your office or area, your Access and Privacy Coordinator will help you through that response process. But in order for an informed and FIPPA-compliant access decision to be made, you all play a part. The reason you all play a part is because while your public body's Access and Privacy Coordinator may know the detailed requirements of FIPPA, you are the subject matter experts on the records that have been requested. Your knowledge is important in making the access decision. Access and Privacy Coordinators, who are those appointed to be the FIPPA contact and resource for your public body, will help with coordinating the response process. To do this, they'll be aware of the detailed requirements of FIPPA. For example, they'll know about the timeframes involved, if extensions are permitted, any fees that can be charged, if a request should be transferred, the grounds for refusing access, and the communication requirements to the applicant with respect to all of those things. Because those with expertise with FIPPA and the requested records is necessary, teamwork, communication, and timeliness are the keys to a successful response process. With respect to timelines, the first thing you can do as part of the team is to be mindful that the response process is deadline-driven. A response to a request for access must be provided within 45 calendar days of receiving it. The FIPPA clock starts ticking as soon as an access request is received. So if an applicant didn't know that their request should go to the Access and Privacy Coordinator and it lands on a desk in your area, get it to the coordinator right away. As you can see from this slide, there are some situations that affect the response time limit. For example, extensions to the 45-day response time limit may be taken, but only under very specific circumstances. Some requests can be transferred to another public body, but this must be done within 10 days of receiving the request. And the response time limit is affected if fees are assessed for processing the request, if consultations with third parties are necessary, or if clarification is necessary to identify the records being requested. The determination to use any of these tools provided by FIPPA needs to be addressed as soon as possible so they can be carried out within their specific timeframes. Your Access and Privacy Coordinator needs to be involved in this determination process. There is no specific form that must be used when a person wants to make a request for access under FIPPA, but the law does require a request for access to be made in writing, provide enough detail to enable an experienced employee of the public body to identify the record being requested, and where practicable, be submitted to the public body's Access and Privacy Coordinator as provided on the Information and Privacy Policy Secretariat's website. Although a specific form is not required, the Information and Privacy Policy Secretariat provides a form that applicants may complete and submit to the public body that has custody or control of the records they wish to access. Some public bodies may even have chosen to develop their own form to facilitate the process for making a request for access under FIPPA. When your Access and Privacy Coordinator receives a request for access, they will try to determine which offices within your public body may have the records that the applicant is seeking, and they will request a copy of those records. It's important that your coordinator receives all responsive records in order for the necessary analysis to be completed. It's important to note that when a request for access is submitted to a public body, it contains personal information about the applicant and perhaps other individuals. Part 3 of this FIPPA awareness presentation on protection of privacy discusses how we are required to protect personal information. In the context of requests for access and the process for responding to them, any personal information involved should not be shared with anyone unless it is necessary. For example, the name of the applicant is not necessary to share with employees of the public body who may need to search for requested records unless the applicant is requesting access to records containing their own personal information. Please listen to Part 3 of this FIPPA awareness presentation for further explanation on the limits of a public body's use or disclosure of personal information. In most cases, the teamwork starts with the search for all records that are responsive to the request. Being the subject matter experts, you're in the best position to determine which records are within the scope of the request. If it's difficult to make this assessment, discuss this with your coordinator. Also let your coordinator know if the quantity of the records to be searched or gathered seems unreasonable considering the time frames. Extensions may be in order. Otherwise, the search begins. FIPPA requires that we assist applicants by responding to access requests without delay, openly, accurately, and completely. The Manitoba Ombudsman's Office explains in one of its practice notes that if adequate searches have not been conducted, all relevant records would not be identified, and the resulting response would be inaccurate and incomplete. The practice note also states that reasonable efforts would include a strategy to identify and locate all responsive records. What does this office mean by strategy? If the request is for a record or a collection of records that is difficult to find, what is the most logical way to proceed to try to locate them? The strategy is often determined by what is being requested. Taking a W5 approach may help you to decide on a strategy. For example, based on the access request, who is likely to have those records because they worked on the file or were involved in communications? Was a contractor involved? Where do the records reside? In a shared file system? In individual offices? With third-party service providers? Stored off-site? On someone's phone or other portable device? When were the records created or received? What types of records exist and in what format? With FIPPA's definition of a record being a record of information in any form, we need to look for all hard copy and soft copy records. Ultimately, we should be able to explain why the approach that your public body took to search for the records was considered adequate for locating all of the records. And if the end result is that there are no responsive records, can you explain why that is? You and your Access and Privacy Coordinator will work as a team to determine the best approach for finding all responsive records. Considering these W5 questions can help you with whose records need to be searched, who should conduct a search, where to search, and what search terms or date parameters will be effective for the search. As mentioned in a previous slide, it is important for your Access and Privacy Coordinator to receive all responsive records. This may feel a bit scary, as you may think turning these records over to your coordinator means they're going to be disclosed. This is not the case. Handing the records over just means that they've been identified as within the scope of the request. Now they need to be analyzed to determine whether or not access can be granted to them. Carrying on with why your expertise is so important to the process, that right of access that was mentioned earlier is not absolute. It isn't as simple as ask and they shall receive. Your knowledge helps to make the decision on what information can be disclosed and what information should be protected. In the spirit of this part of FIPPA, the default thinking is disclosure. FIPPA states that any person has a right of access. But caution must be exercised to protect information that requires it. I think we all get that gut feeling that it isn't right to disclose records that contain personal information about someone else or other information that is sensitive and can actually cause harm if it's disclosed. FIPPA recognizes this by providing for exceptions to the right of access in order to safeguard private and confidential information. These exceptions to disclosure are specific provisions of FIPPA that authorize a public body to refuse someone's request for access to records or information within a record. We'll discuss some of the more common exceptions at a very high level. You're certainly not expected to know each and every exception in order to help someone with the response. That is where your access and privacy coordinators will come in. But any concerns that you have if the information were to be disclosed are very often tied to one or more of these exception to disclosure provisions. Therefore, your part will be communicating your disclosure concerns to the Access and Privacy Coordinator. But knowing generally what the exceptions to disclosure are allows you to understand that your concerns are important and that they are important to discuss with the Access and Privacy Coordinator to properly apply the law. This is because in many cases, the coordinator doesn't know the history or the other circumstances surrounding the records or the issues they represent, and this context is important in determining if one or more exceptions to disclosure apply. In most cases, the exceptions are based on the concept of harm, so a good question to ask yourself is what harm will be done if the information is disclosed? There are two main types of exceptions to disclosure. Mandatory exceptions are those that require a public body to refuse access. Discretionary exceptions are those that allow a public body to grant access even if an exception applies. Let's first talk about the mandatory exceptions to disclosure. You can recognize a mandatory exception to disclosure because the wording in FIPPA for each one of them starts with the head of a public body shall refuse, followed by a description of records or information within a record. These are the types of records or information that applicants cannot have. We'd be breaking the law if we disclosed it to them in response to an access request. On this slide are the headings that appear in FIPPA for the mandatory exceptions to disclosure. The headings are for reference only and do not represent the actual exceptions themselves. I'll say a few words about each heading, but it's extremely important to turn to FIPPA itself for the specific and full description of records or information under each of the headings. On this slide, the term third party, in the context of FIPPA, is anyone other than the applicant or a public body. For the exceptions relating to the privacy of a third party, FIPPA requires the head of a public body to refuse to disclose personal information that would be an unreasonable invasion of a third party's privacy. This provision of FIPPA goes on to describe situations, information, and considerations to determine when disclosure of personal information would be an unreasonable invasion of someone's privacy. A few examples of the personal information described are someone's health or financial circumstances, information about or provided by an individual as part of an investigation, someone's racial, political, or religious beliefs, and employment or educational history. For the exceptions relating to the business interests of third parties, FIPPA requires that access be refused to information that could harm the business interests of a third party, such as a trade secret, information that may harm the competitive position of a business, or interfere with their negotiation processes. For cabinet confidences, FIPPA requires that access be refused to documents and information that would reveal the substance of deliberations of the Cabinet of the Manitoba government. And for information provided by another government in confidence, FIPPA requires government departments and agencies to refuse access to information that was provided in confidence by another government, such as our own province's local public bodies or public bodies of other jurisdictions, both within and outside of Canada. As mentioned, these explanations are very general. FIPPA gets far more involved. Your Access and Privacy Coordinator will help. In fact, your coordinator will likely probe you further on the disclosure concerns you express. What the coordinator is doing is making sure that they can support how an exception to disclosure squarely applies to information or records to which access will be refused. This is important to properly apply the law and will assist should there be an investigation by the Manitoba Ombudsman's Office. Let's move on to the discretionary exceptions to disclosure. Again, discretionary exceptions are those that provide the public body with the discretion to decide whether information can be disclosed or not. You can recognize a discretionary exception because the wording in FIPPA for each one of them starts with "the head of a public body may refuse," followed by a description of the records or information. With discretionary exceptions, the important thing to remember is that the consideration process of whether to refuse access or not should be a two-step process. You'll want to ask yourself, first, does the information fall under the exception? If so, then you'll ask, should access be refused? Just because the information may fall under one or more of these exceptions doesn't mean that access to the information should automatically be refused. The exercise of discretion must take place. You'll want to be able to explain what the reasons are for deciding to withhold the information when you have the discretion to disclose it. Generally speaking, there are 14 categories of discretionary exceptions to disclosure in FIPPA. This slide, and the two other slides that follow, list most of the reference headings for those categories of exceptions. Again, the actual components of each exception to disclosure must be thoroughly examined. Let's take a look at them. FIPPA permits public bodies to refuse access to information or records that would harm the relations between the Manitoba government or a government agency and other governments if disclosed. The list of other governments represented in this exception is the same as the list in the mandatory exception discussed on the previous slide, respecting information provided in confidence by another government. Advice to a public body gives public bodies the discretion to refuse access to information that reveals communications that lend to the formulation of a decision. This exception is intended to encourage the free flow of advice and candid discussions that are necessary to make informed decisions. Examples of such communications include advice, recommendations, deliberations, analyses, proposed plans, or draft legislation. Similarly, under a separate exception to disclosure for local public body use only, access to draft resolutions or bylaws or records revealing the substance of in-camera deliberations may be refused. A request for access to information that would be harmful to individual or public safety if disclosed may be refused. Law enforcement and legal proceedings gives the head of a public body the discretion to refuse access to information that would be harmful to law enforcement or legal proceedings if it were disclosed. The specific provisions refer to such things as investigative techniques, custody or supervision of an individual in custody, and the conduct of existing or anticipated legal proceedings. Continuing further with the discretionary exceptions to disclosure, a request for access to information that would be harmful to the security of properties or systems may be refused. This relates to such things as our passwords to systems, fleet vehicles, or workspaces. A public body may refuse access to information that is subject to any type of legal privilege, such as solicitor-client privilege or litigation privilege. Economic or other interests of a public body permits the refusal to information that can, if disclosed, harm your public body's or the government's economic or financial interests or negotiating position. This exception is, in some ways, like the mandatory exception to disclosure that protects the business interests of a third party. A request to information that could reveal or harm labor relations matters of a public body as an employer may be refused. And to finish off the discussion of discretionary exceptions to disclosure, a request to access information relating to a public body's investigation into the employment-related conduct of an employee may be refused. The exception to disclosure relating to confidential evaluations about the applicant permits a public body to refuse an applicant's request for access to their own personal information that was provided in confidence by another to determine their suitability, eligibility, or qualifications for employment or a contract. And last on this slide, a public body may refuse to provide access to information that will become public within 60 days from the date the access request was submitted. After this very brief review of some of the exceptions to disclosure, here are some closing comments about them. Contrary to what many presume, FIPPA does not provide a convenient black and white list of documents that can and cannot be disclosed. Instead, the exceptions to disclosure consist of descriptions of circumstances, information, and context that must be considered to determine whether information can be disclosed or not. It's also important to note that most of the exceptions have limits. For example, if an individual consents to the disclosure of their own personal information, then a public body can no longer refuse access based on those invasion of third-party privacy exceptions. Also, information that is publicly available, in the public interest, or required to be disclosed in accordance with another law are examples that preclude refusing access based on certain exceptions to disclosure. And when it comes to employees of a public body, some information related to their employment, such as salary ranges, employment responsibilities, or employment expenses, can be disclosed. This is intended to balance the right of privacy for employees as individuals or third parties with the public's expectation of government transparency and accountability. Ideally, at this point in the response coordination process, the records have been located and provided to your Access and Privacy Coordinator, and you've discussed the concerns you have with respect to the harm that can come if they're disclosed. Now what? In most public bodies, the next steps are carried out by the Access and Privacy Coordinator. They consist of preparing the records for disclosure, preparing a response letter that is compliant with FIPPA, and sending the response within the legislated response timeframe. Preparing the records for disclosure involves reviewing them word by word so as only to sever or redact records or information within records, and identifying those redacted portions with the specific exceptions to disclosure that authorize the refused access. Sometimes full records or pages are severed, meaning that every single word on those pages fall within one or more exceptions to disclosure. Sometimes parts of pages are severed, meaning that only certain portions fall within one or more exceptions to disclosure. But it's important to note that just because some information in a record cannot be disclosed, that doesn't mean that access to the entire record should be refused. FIPPA states that if information can be reasonably severed, the applicant has a right to access the remainder. When preparing the response letter, FIPPA requires the applicant to be informed of the access decision, which will either be access granted in full, access granted in part, or access refused, how access to the records will be provided, and if a record or part of a record is refused, the reasons why, whether that be because the records could not be located, or they don't exist, or there are specific exceptions to disclosure that apply. The response letter must also contain contact information in case the applicant has any questions about the decision. And finally, if access is refused, the applicant must be informed of their right to complain to the Manitoba Ombudsman about the decision. The response coordination process comes to an end when the response letter is sent. As required by FIPPA, the response must be sent within 30 days of receiving the request, or within an authorized extended response timeframe. I hope you can now see how you as the subject matter experts and your Access and Privacy Coordinator makes for an effective team that can make informed and FIPPA-compliant access decisions. For more information about FIPPA, there are several resources that can assist you. Our office has a FIPPA website that contains further information to help you to understand and administer FIPPA, such as the legislation itself, questions and answers, and instructions about how to make a request for access to a public body or how to make a complaint to the Manitoba Ombudsman. Of particular assistance is the FIPPA Resource Manual that essentially explains each provision in the main parts of FIPPA. The Manitoba Ombudsman's website also contains valuable guidance material, such as investigation reports and practice notes on a variety of FIPPA and FIA-related topics. And of course, legal counsel is an important resource. While the Information and Privacy Policy Secretariat may be able to assist you with factors and relevant portions of FIPPA to consider to help you make your own decisions, legal counsel can provide you with direct legal advice. And for those with government departments, the Government Records Office on the Manitoba Government's intranet site has guiding information related to managing records, including an introductory course that is offered through Organization and Staff Development. If you are not with a government department, you can check with your own public body's records manager or officer for applicable policies, procedures, or guidelines. Thank you for your interest in the FIPPA Awareness presentation. With this information on the Access to Information part of FIPPA, you'll be in a better position to effectively contribute to your public body's responsibility of making access decisions that balance the public's right to know with the need to protect private and confidential information. Please consider listening to the other parts of the FIPPA Awareness presentation for more valuable information that will assist you with carrying out your responsibilities in compliance with FIPPA. If you have any questions or comments, please contact us at the Information and Privacy Policy Secretariat.